Welcome everyone that has joined. We're really excited to have you guys here. We're excited to share this information with you this morning. So we're going to be covering screen or be sued and how one case really changed property management forever. Some of the things that we're going to cover is a specific case and that case background and the legal consequences of that case, how it affected that property management company, duty of care and screening expectations. We'll cover insurance and risk considerations, how to monitor unusual employee or vendor behavior and what to do about that, and then some practical steps that you can take today to protect your property management company, your teams, your tenants, etc. We'll end with a question and answer, a Q&A at the very end. That being said, if you guys have questions come up while we're covering this information, we definitely encourage you to throw that in the chat. We can cover questions as we're going through and as we're going along. So let's go ahead and jump in. My name is Jen Free. I am Director of Sales with Cloud-Structure. I have a background of working on the operation side. So I started off as a leasing consultant, worked my way up to property manager. That being said, I am very familiar with what you guys deal with on a day in, day out basis in terms of security issues, property damage, lease violations, tenant issues. The list goes on and on. But I have been working on the vendor side with Cloud-Structure for the past 4 years, and I truly am passionate about what we do here at Cloud-Structure. I'll go into what we do a little bit later in this webinar presentation. But my background being in the operations side is why I am passionate about having security measures present at property management companies. We also have Melinda Macbeth. You've seen her on a few of our webinars. We're really excited to have her here again. But she is counsel with Offutt Kerman, and she is a leading litigator specializing in landlord defense and liability law. Melinda brings a legal insider's perspective on really how to safeguard your properties from property management risk. Melinda, we're excited to have you here.
I'm happy to be here. Thanks for having me.
We also have Megan Davidson. She is VP at Alliant Insurance. She is a risk management pro who really helps multifamily portfolios navigate those insurance claims and really reduce exposure. Megan will be sharing some proactive strategies throughout this webinar to really help you guys lower your risk. Megan, thank you for joining.
Oh, very welcome. Thank you.
So Cloud-Structure is a cloud-based video management system that offers AI surveillance as well as remote guardian services. So what we do is really integrate that AI and those analytics to create more of a proactive approach to security at your property management's properties throughout the nation. So we're really excited to be able to share that we've held strong with a 98% deterrence rate, which means if you're utilizing remote guarding, you have that proactive deterrence of the speaker on property that's able to cut in real time while that unwanted activity is happening. And that really helps deter that unwanted activity from progressing any further. And again, I'll cover this a little bit more later on in the presentation here. But Melinda, go ahead and give us a little bit of your background and Offutt Kerman.
Sure. So the Offutt Kerman is one of the fastest growing law firms in the United States. We have offices all over the country. I believe actually this slide is might be slightly out of date because we continue to add new practices in different states across the country. I feel like every week or two I wake up and find out I have new colleagues, which is awesome. We have a very robust landlord representation group. I am part of the Maryland group, so I work with landlords across the state of Maryland. We also have a DC team. I see one of my colleagues from the DC team is joining us in support today. We have attorneys in Virginia, basically all up and down the East Coast. So if you have any type of civil litigation needs, whether it's landlord, tenant, or something else, Offutt Kerman can help.
Great, Melinda. Thank you so much. And Megan, and we do want to let you guys know we were having issues with the video. She's not invisible. She is here. But Megan, if you would tell us a little bit about your background and Alliant Insurance.
You bet. All I'm going to say is I stopped counting at 30 years, and I am a specialist in both insurance and risk management. I joined Alliant about 7 years ago. They're one of the top 5 brokers in the country, probably one of the largest brokers you've never heard of. We've got over 12,000 employees, and we talk about having 2.5 million multifamily units that we protect annually. We're actually breaching 3.5 million more now. About a third of those, 27 to 30%, are affordable. And so that happens to be my particular area of expertise, but I do both market and affordable housing.
Really glad to have you here, Megan. We're excited for everything that you have to share. All right, so today's conversation is about a case that has fundamentally shifted how courts, juries, and insurers really view property management risk. The Billingsley verdict wasn't just a tragedy, it really set a precedent. Before we get into legal standards and insurance implications, I really want to pause and acknowledge that this case involved real people whose lives were permanently changed. And our goal in discussing this is not to sensationalize it, but to understand how to prevent tragedies like this in the future. So, Melinda, go ahead and start us off. Do you want to quickly run us through the case?
So in September of 2023, news broke that a young woman who was a tech CEO here in Baltimore City had been murdered pretty horrifically. There was a 48-hour citywide manhunt for this person. And as the details unfolded, it came out that several days prior to this murder that this person committed, Jason Billingsley, he had also attacked a man and a woman in their apartment in Baltimore City. He knocked on their door, said he was maintenance, said there was a leak in the kitchen and he needed immediate access. And when they let him in, he violently assaulted both of them. He assaulted the man first, incapacitated him, and then proceeded to assault the female victim in some pretty horrific ways. I'm not going to go into details about it. There's news all over the place about the case. If you're interested in doing more of a deep dive about it, it's available to you. But he attacked her with a knife. He left her for dead. He set the apartment on fire, and then he left. And a couple days later, committed this murder. As the case unfolded, it came out that this gentleman, Jason Billingsley, had quite a long history of criminal convictions, first-degree assault, first-degree sexual assault. He was actually on the sex offender registry. And in 2002, less than a year before these crimes were committed, he had been released from jail after doing 7 years in prison for one of these assaults. After all of this came out, the two residents of the apartment who had been attacked turned around and sued. They sued the landlord and they sued the property management company. And the basis of their suit wasn't that the landlord and the property manager had committed these crimes, but rather that they had been negligent in hiring Jason Billingsley. It came out later that one of the owners of this property met Mr. Billingsley in a bar. And the details of that conversation aren't really known. But at a certain point, the landlord offered to let Mr. Billingsley stay in one of their vacant units for free without paying rent in exchange for doing odd jobs around the property, things like cutting the grass. They claim that he was never formally an employee and that he never had access to any tenant units, but he clearly did have access to at least one tenant unit because he went in there and he committed this crime. The tenant sued the landlord for negligence. At the end of last year, the case finally reached its conclusion, and the jury awarded those individuals $21.5 million. The case is now on appeal. The landlord has appealed that verdict, that ruling. But regardless of what ultimately happens with the case, it really gave me pause when all of this came out, not only because it's so close to home, because I live in Baltimore City myself, but because of what I do, working with property management and landlords. I feel like it's a very powerful lesson for how potentially a good deed, trying to help someone out, give them a place to stay, can have devastating consequences, not just on your business as a landlord, but on your tenants' lives and their safety. So I reached out to Cloud Structure and said, I really think we need to talk about this one, guys. This is a big one.
And Melinda, without reliving the trauma, there were obviously observable behaviors. He was lingering in lobbies, unusual presence, shyness around surveillance camera. Can you elaborate on that a little bit?
Apparently, people had reported that he creeped him out, I guess is the best way to say it. I think just sometimes when you're interacting with someone, your intuition will sort of start sending you warning bells that there's something wrong here. And it came out later that he was engaging in behavior that people found concerning, that he just kind of creeping around the property, lingering in different places. On top of that, it would not have taken a lot of research to figure out that he had a pretty substantial criminal history and that he was on the sex offender registry. It took me maybe 10 minutes of research the other day when I was preparing for this to find all of his criminal convictions. The landlord did no screening of this individual at all and didn't really put them through the formal hiring process. Had they done that, had they just typed his name into Google like I did, they would have found out that this was a bad dude.
And Peter is asking, is that 21 million from the landlord or the property management company, or were both found liable?
It was against both of them. There seems to be some inner overlap between the ownership of the landlord entity and the ownership of the property management company. There's at least one individual who is a co-owner of the property management company and a co-owner of the actual property, the landlord. So there's overlap here, but both of them were pursued and found liable.
Now, Megan, when an incident stems from an informal or undocumented working relationship, how does that really affect how insurers analyze responsibility?
Great question. So the lack of documentation is less important than the level of control that is exercised. So for the property management company, with or without documentation, an employee made the decision to have a fellow he met in a bar live on property and perform maintenance work in exchange for an apartment. By doing this, he established an employer-employee relationship and put his company in the position of being responsible for that individual. So Jason Billingsley's actions became essentially the actions of an employee of the property management company. And for the owner of the property, they, according to the lead attorney for the two injured plaintiffs, were allowed to ignore their duty to keep tenants safe. And further, the attorney noted that the owner, by choosing this particular location to renovate houses and split rooms, was choosing profitability over safety. So insurance companies for both the property management company and the property owners will be reviewing the management agreement to determine where contractual liability lies, as well as research which entities had how much in limits. Because when it comes down to it, you have two different entities, both are found responsible. We don't necessarily know who has how much in limits, but that will come into play as well.
Very important to remember. And Melinda, another question for you. So when someone is given access to private residences, even informally, how does the law view that access in terms of duty of care?
I think it is a high duty of care. If you are allowing people access to resident homes, that's someplace where you are already promising to keep them safe. There's an implied warranty of habitability and of safety every time you rent out property to a tenant. So even though the general rule is that landlords are not liable for criminal acts of third parties, in this case, they were found liable because they had a duty to ensure that whoever is going in and out of units is someone that has been appropriately screened and is safe. Now, obviously, you can't control everything that your employees are going to do, and you can screen someone up one side and down the other and still have a problem. But no screening at all is really the danger zone, because particularly in this case, the danger was known and foreseeable. It not necessarily known to the landlord, obviously, because they hired him, but it should have been. It would have been a quick Google search or a quick background screening would have told this landlord, this person is not safe at all, shouldn't be anywhere near someone else's home, children, none of those things. So the fact that they didn't bother to do any type of due diligence is really where the problem started here. If you've attended any of our past webinars about various landlord liability, one of the things I always say is it foreseeable for the landlord to expect something like this to happen? And if it is, that's when the liability attaches. First time a dog bites somebody, you're probably not responsible for that. The second time it happens, you probably are. In this case, If you hire someone and they randomly commit a crime, you're probably not going to be on the hook for that. But if you hire someone that you should have known was a criminal, then that's your problem, and it's a big problem.
Yes, going up a little bit in the chat, both were found liable. The totals now come to nearly 50 million, and that property management company actually had to declare bankruptcy after that verdict. Thank you so much for sharing that fact in the chat. We have another question, great question. Sharon is asking, we have a couple of owners that place their own handyman in some units and do not run backgrounds, credit checks, etc. And we have them sign off that they placed them and we do not have liability, but they are on our paper. Should we refuse them overall and let the owner handle them directly to fully shield us?
I think so. I'll let Megan probably has some thoughts on this too, but if they are working on your property or with some kind of authority, then yes, you are potentially liable for that, even if you had nothing to do with their hiring at all. I think the one thing that this case has taught us is that you cannot just hire random people without background checks. You need to background check everybody at this point, and you need to be really careful with who you allow access to residents' homes. That's the biggest one.
I would agree. I would also say anyone who has keys to the premises, because if these folks are working, if these handymen are working on premises, they're being given keys. Anyone who has access to a key should be background checked.
Right. And I mean, in this case, I don't believe Billingsley actually did have keys. He couldn't have gone in on his own, but he held himself out as maintenance and they let him in based on that. So in that instance, that was enough. He held himself out as having some sort of authority, and he arguably did have some authority, even if he had just been hired to cut the grass. Tenants see him around the property doing these odd jobs, then they assume he's safe. So when he comes and knocks on the door and says you have a plumbing emergency, they're going to let him in.
But even if they don't have keys, wouldn't they be perceived as maintenance since he's there working at the property? I mean, it's
Yes.
a perception of the resident. Yeah.
Yeah,
Yes.
for sure.
No, that is great. And that actually leads us to our next slide. So hiring expectations, and obviously you guys are catching on the importance of that. These maintenance workers, handymen, they do in fact have access to individual residences. So it's now considered a high risk role. So Melinda, could you cover some of the expected practices that can help protect these property management companies?
First and foremost, you need to screen them on their way in the door. And you need to make sure that their background doesn't raise any red flags that might make them a danger to you, your property, or your tenants. That's just generally good practice. You screen your tenants, you should be screening your employees as well. I would recommend pre-hire background checks. I think that's a good idea. You don't want to find out after you've already brought them on board that this is a problem. These are things that you should be doing before you move to the next steps. I think you also need to keep an eye on your vendors and your contractors, because sometimes you have, an air conditioning maintenance guy in there from one of your vendors. You don't know who that person is. You are relying on your vendor having screened them. So while you can't be expected, of course, to go screen all of your contractors' employees, you need to make sure there's some sort of an agreement in place between you and the contractor or the vendor that protects you. Make sure that they have insurance, liability insurance. Make sure that you have liability insurance. Megan is going to get into this later, I believe. Make sure that you are clear on, should a problem arise, who has the liability. Usually the contracts will lay all of that out. If something bad happens, who's responsible for it, who has to defend it, are you indemnified by the other side, or are you indemnifying them? Are you committing to, if something happens, we will come in and we will defend your employee who was there working for your company on our behalf. It can get pretty complicated, but what I always say is you need documentation and you need a paper trail. If you can show that you've taken all of these steps to sort of cover yourself and protect your tenants, then when an outlier thing happens, you will be in a better position than the landlord was when they hired Jason Billingsley. I think you
Yes.
should also make sure that you have clear documented policies. Put it in writing. This is a fair housing thing too. I mean, if you have policies on how you handle certain things, they need to be in writing. That way you can turn around and show later, this has always been our policy, our plan for how we address these things. Having something that's clear in writing that all of your employees know about and know that they should be following, that is very helpful.
And that's always a common theme when we have you on our webinars, Melinda. Document, document, document. It's only going to help you in the long run.
Yeah, people are like, does she ever say anything else? No, I don't. This is it.
That's how important it is.
That's right.
I'm seeing in the chat, Nicoletta, you have your hand up, I believe. I don't believe you have the opportunity to chime in, but if you do have a question or even a comment, go ahead and throw it in the chat. We'll make sure to cover it. So Melinda, or I'm sorry, Megan, I actually want to transition over to you. So what do carriers expect in terms of screening policies in light of this verdict of this case? Are they going to expect documented rescreening policies?
So typically, insurance companies ask right in the application whether or not you do a background check on employees. So they're talking about at point of hire. Oh, so that first and foremost is important. You want to be able to answer that question, yes. If you don't, it's a red flag to insurance companies. Secondarily, insurance companies don't necessarily ask about rescreening, but look at the positions that your employees are in. For instance, anyone who's in a high-risk position, so somebody in finance, somebody in maintenance, a site manager who has access to the premises, any of those folks should be rescreened, and you can make the decision, should it be every 2 years, 3 years, 4 years, 5 years, but people should know they're going to be screened before they're hired, not after. Don't hire subject to, don't hire until you do the background check, and then let them know they will be rescreened at some point.
And I think it's also a good idea to put in your employment contracts, whatever your hiring documents are, that if your employee is subsequently convicted of a crime or arrested of a crime, they are required to report that to you as the employer so that you can address it. Doesn't mean that they're always going to do that, but at least that way you've sort of covered your bases a little bit better, that is an expectation, and them not reporting it is a divergence from your normal policies and procedures.
And it looks like we have a comment in the chat. Morgan, it looks like you might even work for a tenant employment screening company. So another problem she sees is when people are not background checking individuals, the property gets a reputation for an easy place to rent or work at. Many people with criminal backgrounds communicate with each other and know what kind of background checks they run and where they can get by. She sees this a lot since she's a tenant employment screening company. We see a lot of people who go from apartment to apartment, hoping no one checks the county, state, courts they come from. Very great point there. Morgan, thanks for sharing. Let's go ahead and transition to the next slide here. So duty of care. Let's talk about duty of care, because property manager probably would not think of the role of a guy doing odd jobs throughout the property, even being a full-time maintenance worker, as a high-risk job that required screening, but the jury did. I know we kind of just covered that in the last slide, but Melinda, do you think that was reasonable?
I do, actually. I think that the jury probably reached the right conclusion here, just because of, and obviously the details are shocking, but the fact that all it would have taken was a simple Google search of Jason Billingsley's name to find out that he was a dangerous individual. I mean, it's such an easy step that you should be screening all of your employees when you hire them for a variety of reasons. One that I see most frequently is property management employees stealing rent checks from your tenants. So it's not always going to escalate to an attempted murder and an arson and everything that we're talking about today, but it protects you in so many different ways to screen everyone who comes through your door to the extent that you can. It avoids a lot of issues, and probably would have avoided this too. Now, if they had screened him and hired him anyway, they would still be in the same boat. But if they had screened this guy, I would hope that they wouldn't have allowed him to live on the property. They would have said, this is a bad idea. This person is is dangerous. And then he never would have had the opportunity to harm these two individuals. He may have still committed the murder that he did several days later, but he wouldn't. I don't think this first crime would have occurred had the landlord not basically rolled out the red carpet for him.
And you bring up a good point, Melinda, the idea that everyone that walks through the door should be screened. So how should ownership groups think about vendor screening versus direct employees?
Right. I mean, that again, it's not really practical to screen all of your vendors' employees, but you can make sure that there are robust contracts in place that protect you if your vendor did not do proper screening. Make sure that the liability insurance responsibility is clear. I don't want to go too deep into that because that's Megan's bag. She's going to explain it much better than I can. But those are all important things to keep in mind. You have a duty to keep your tenants safe to the best of your ability. And this is something that you can control and you should be controlling.
Absolutely. Megan, do you have anything to add to that?
Yeah, for sure. So, what I would be doing as far as the vendors go is I would make the vendors responsible. Number one, in the contract, I would make it mandatory that all their employees be screened. And secondarily, I would make sure that they have adequate liability limits so that if for some reason they didn't do their due diligence and there is an incident, that they have the financial backing, meaning insurance, to pay for any incidents that might happen as a result. But making them responsible to do that in writing really kind of covers your bases.
All right, let's go ahead and move on. So the phrase we keep hearing is access equals responsibility. And that's a lot of people at a multifamily property. We've covered employees, tenants, vendors. So Melinda, how are courts going to interpret foreseeability in cases involving criminal acts by employees or vendors after this verdict?
I think that the protections for tenants are going to continue to expand. We've been seeing this trend for years now of increased tenant protections, increased liability to landlords for a wide variety of issues. Here in Maryland, we have a new tenant mold safety law, which is not a criminal issue, but it's really the noose is tightening around landlords basically from every angle at this point. And so the best way to protect yourselves is to make sure that you have a thorough process to document all of this stuff. I'm going to say it again. You got to document stuff. Keep logs. Megan and I did a webinar last year about slip and falls and tenant safety from a different angle. And one of the things that we sort of hammered on is you need to be walking your property regularly and taking note of things that are potentially dangerous for your tenants. The same thing is true here, although it's less of a walk around and notice. Although sometimes you can maybe if these people had walked around, they would have noticed Jason Billingsley acting weird and thought, okay, maybe we need to address that. You need to have eyes everywhere to the extent that you can. Keep an eye on everything and document all the time. Whatever you're doing, write it down to show that you did it. If you can show this sort of consistent pattern of trying to maintain safeguards for your tenants to the best of your ability, that goes a long way. Goes towards showing, that you did everything that you could to try and avoid what you thought was foreseeable. And then if things pop up, you're less likely to be on the hook for things that you had no control over and no anticipation of. But I do think that a lot of judges, particularly where I am in Maryland, which is very tenant friendly, these tenant protections and the liability of landlords is just going to continue to grow.
So to continue on with the documentation standard, how does that documentation influence, and I think we all know the answer to this, but how does it influence whether a case settles or goes to trial?
If you have no documentation, I'm probably going to tell you it's a case that you would want to settle, because how are you going to combat the claims? right? How are you going to show that you did everything reasonable in your power to try and prevent these types of things from happening? You can get up on the stand and say it, but that's pretty much all you can do. You have to be able to back this stuff up with documentation or with video or security logs. If you have a security company, they should be putting down logs every time they walk the property and they do a sweep of whatever's going on. If you can show we're walking the property every hour, for example, and something happened 30 minutes after our last walk and 30 minutes before our first walk, that's sort of like a shit happens kind of thing. Pardon my French. But if the last time you walked the property was 3 weeks ago, I think you're going to have a problem.
Yeah,
You know what I would also, I'll throw into that. The first thing that I ask a client for if they've had an incident on premises is a copy of the videotape. So we had a set of circumstances within the last year where a fellow said, "Hey, I slipped and fell on the stairs coming home." And there were two stairs on the exterior of the building. There was a perfectly placed camera, might I add. As this fellow was coming up to the staircase, he grabbed onto the railing. He got to the second step, and he did, by the way, have a prosthetic leg. He was very unsteady. He literally just fell backwards. He didn't slip. There was nothing on the ground that was an issue at all. He was simply unsteady on his feet. That videotape was the difference between him being able to settle and have a claim against the insurance company and the owner and the management company, and it being dismissed. So having that information visually to be able to present was absolutely priceless.
That is a really great point, Megan. Having cameras throughout your property, the ROI, the return on investment of having that extra eyes throughout the property could potentially be huge in the long run. And Megan, continuing on with the documentation topic. So when carriers evaluate a submission, how much weight is placed on documented policies versus informal practices?
The upside is you really want documented policies. And this is where, honestly, legal and insurance, there's some blurred lines because we both step into each other's territory all the time in a positive way, because we understand what's needed to create a good defense. And documented policies are your defense, but you have to consistently follow those. So as far as employee screening goes, some insurance companies will say, "Okay, if you screen, let me see a copy of your screening policies." In other cases, if there's a lawsuit, they're going to say, "Let me see your screening policies, and did you follow them? And if you follow them, did you document that you followed them?" So that is your defense right there. And so we just strongly encourage a documented policy and documenting that you followed it.
Thank you. I want to jump to Nicoletta's question real quick, and then we'll move to the next slide. And this is bringing back memories. It's a great question, but what happens if a new management company is hired on and an existing tenant in the building has a lengthy criminal record and is currently in court for alleged sexual assault? What is the management company's duty at this point?
If you came to me with this scenario, Nicoletta, I would tell you that you need to terminate that person's lease, or at least try to send them a notice to vacate. Most leases have a provision in them that will allow a landlord to terminate the lease for criminal activity, criminal behavior, new criminal convictions, things like that. Now, most leases also have something in there that says basically, "Hey, look, we're screening you for X, Y, and Z." That doesn't necessarily mean that every single one of the people living on our property has been screened for X, Y, and Z. These policies can sometimes change over time. So we are not necessarily guaranteeing that every one of your neighbors has been screened in this manner and doesn't have any of these issues going on. So if you are coming in and taking over another management company's supervision of the property, it does does become your problem. You kind of take the whole bag. They leave the bag and you pick up the whole bag. So whatever they have left you with is now your problem. But if you are not aware of the problem until you become aware of it, that's when the liability starts to attach. So I would get that guy out the second that you find out that he's facing allegations for sexual assault. Now, you may go in front of a judge, and the judge tells you, I'm not going to let you evict this person for whatever reason. But at least then you have, again, you documented, you have a paper trail showing that you've done everything that you could do to try and ensure that this person is out of the property and or the property is safe. That way, if he commits another crime, your risk of liability is much lower because you did everything that you needed to do to try and prevent and stop it. It's not that you have a completely crime-free property. That's the goal. We'd like that for everywhere, but that's not the standard. It's not completely crime-free. It's foreseeable and preventable crime.
All right, Megan, we're going to transition into the insurance side of things. And I know there's some important information on this, but for the sake of time, could you pick out a few of these that you think are most important to cover, and we'll move on?
Yes. So I'm going to say for all of you, the first thing that your insurance companies are going to ask you for is a copy of your management agreement. So contracts are important. If your current insurance broker is not willing to review your contracts, I would take that as a big warning sign. This is a big deal. Contracts change. Contract language changes regularly. It evolves. So I would regularly have your contracts checked. The rest of these key factors take a look at, but all of these particular factors, everything that happens before you place your coverage has an impact on coverage. Your operations has an impact of coverage on costs, on what coverage is excluded or included, whether or not you can defend a claim, and how much is enough in limits. Now, punitive damages, some states allow you to insure them, some states don't. So it's always good to know which states do and which states don't. Quick Google search will get you there. So essentially, what I would say is whatever you do, document it. Monitor that your documentation process is working. Without that documentation, defending a claim is hard, and you don't want to rely on insurance to pick up the pieces if everything falls apart. So have everything done ahead of that.
And so, I mean, there are so many things I didn't even know before we started talking about this, like the fact that a lot of states don't allow punitive damages to be covered by insurance. So Megan, you've created this flow chart here. Can you walk us through it?
You bet. So the first part of any property management agreement when it comes to indemnity is trying to determine who's responsible for carrying insurance. So this flow chart kind of takes you down if the property owner is responsible for carrying the insurance or if the property manager carries the insurance. So it all starts from there. You really only want one person to be primary. I've seen contracts where there's a mutual indemnification clause. Imagine if there's a claim. You're going to have two insurance companies fighting in court. So the most important part of the contract when it comes to that indemnification is who's primary, right? You don't want people paying for double insurance. So it's double cost and double litigation costs if you go to court, if you don't establish it in that contract. So for instance, if the property owner carries insurance, what they would do is they would name the property management company as a primary non-contributory additional insured with a waiver of subrogation and a hold harmless clause. That means the property owner's insurance will pay for the claim for both themselves and the management company, and they're not going to go back and subrogate against the property management company. They're really intended to be primary. Now, there's also contingent general liability as well as errors and omissions coverage that can be carried by the property owner if the property manager carries insurance. If the property manager carries the insurance, they're going to name the property owner as a primary non-contributory additional insured, again, with that waiver of subrogation and with a hold harmless agreement. They're also going to carry errors and omissions coverage so that if they make a mistake in the management of a property, there's coverage there. Now, errors and omissions coverage does not protect against general liability losses, so bodily injury, property damage, that sort of thing. That's really for mistakes in management. We also recommend that property managers consider environmental coverage, mold, mildew, meth removal, Legionnaire's disease, employment practice coverage, cyber liability, and crime. And as far as on the property owner's side, we kind of bounce back to the general liability on that. Whichever party carries the general liability should carry a minimum of $1 million per occurrence, $2 million in the aggregate, and then have an umbrella or excess liability of $2 to $5 million or more, depending on how many units they're insuring, depending on the amenities, so pools, gyms, computer rooms, things like that. How old are the properties? What kind of issues could there be with those properties? Could there be lead? Could there be asbestos? That would tell you I need to carry higher limits. Something could happen with maintenance. And potentially with that age comes the need for environmental as well. And then risk factors. Think about your crime scores in particular areas. A lot of affordable housing projects are in areas with higher crime scores than market rate because there's number one in need there and the property is affordable. But that also increases your risk of an assault and battery loss. So you need to think about all those risks when you're determining how much in limits you need. And no matter how much you do purchase in limits, that's no guarantee that a loss isn't going to far exceed however much you're purchasing. So reason enters in, budgets enter in, but also consider what your risks are when you're determining what limits to purchase.
And one question to kind of follow up with that. If one asset in a portfolio experiences a nuclear verdict, how does that affect insurability and premiums across the rest of the portfolio? And also, who typically feels that impact more? Is it the owner or the manager?
It will affect both, but really it mostly affects the party that paid for the loss, right? So if, for instance, the management company was carrying the insurance and their insurance paid out, they will be most affected. Now, if you have a large portfolio and one property has a large loss and none of the rest of the properties have a loss, you probably want to keep that property on the main portfolio. And the reason is if you take it off and try to insure that property on its own, especially if it's in a high crime score area, it is going to blow up as far as premium goes. Insurance companies look at frequency as actually a bigger predictor than severity. So if you have one severe loss, sometimes an insurance company will kind of forgive if there's a fair amount of premium. Now, if you're looking at a low premium and a very large loss, you've got an issue. But if you can kind of say, listen, okay, we had $1 million loss, but our insurance has been consistently costing us $500,000 a year for the last 10 years. You've made lots of money. This is a tough year. We appreciate that. But roll the dice on us another year. We're going to do everything to prevent this kind of loss in the future. We've installed more cameras. We're doing documentation. We're doing all the right things. I would say keep that one property that had the loss on with that larger portfolio. But even look at it both ways. Would it make sense to pull that property and do it individually, or does it make more sense to keep it with the larger portfolio where you've got more premium to support it?
And so we're going to move on to the fact that employee screening, it's not a one and done. Billingsley was not a long-term employee, but this verdict really sets the stage, not only for screening employees and vendors, but re-screening. So let's talk about this notion of ongoing risk and how to set yourself up for safe practices, because no one wants to be the property manager that missed a Jason Billingsley and someone got hurt or even worse. So you both have talked about a lot in the past about the significance of surveillance. And we at Cloud Structure never really considered keeping an eye on staff or employees as a primary use case for unusual employee behavior. But what I'm hearing from both of you is that our clients should be using their surveillance for that purpose as an operational necessity. Is that right?
Yes, absolutely. I would have cameras in the office, particularly when you have staff who are handling money or rent. And I've certainly been involved with situations where staff were taking rent checks, washing the checks, and depositing them to their own accounts. If you have a camera on, folks, it's prevention, hopefully, which is far cheaper than the cure. So trying to get money back once it's gone is very difficult. But, especially if people have spent the money and just don't have the resources, you just don't want that problem in the first place. So if people know that there's a camera fixed on their desk, and you can tell them, listen, we don't want there to ever be the implication that you may have been compromised. So we do this as kind of prevention of somebody coming after you and accusing you of anything. That puts it in kind of a place where you're protecting your employees as well.
I agree. I think Megan summed it up very well. It's not just preventing things from happening. Another important part is how you address things after they happen, right? Like if you get a complaint from a tenant about whatever, the maintenance guy is acting weird, or I think my rent money is missing, then at that point you can't prevent it from happening. It's happened. What you need to do now is how you address it going forward. Don't just ignore the complaint. Make sure you follow up. Make sure you document everything. Check your surveillance footage if you have any. I see a question from Sharon about using cameras. I feel like now is a good time to knock that one out. So it depends on where your property is located. Things like ability to use cameras on a rental property, it depends on if your jurisdiction is a one-party consent state or a two-party consent state, right? Here in Maryland, it is two-party consent. So everyone being recorded has to know that they're being recorded and consent to that recording for it to be legal. The exception to that is a little more broad and kind of covers all jurisdictions. And is there a reasonable expectation of privacy? If I'm walking down the street in Baltimore City, I have no expectation of privacy there. I think, and I probably am, on camera at all times whenever I go out there. So I know that. But if you are in someone's house and you go into their bathroom, you have a reasonable expectation of privacy there. You don't think that there's going to be a camera in there. And if there is, and no one has told you about the camera, then that's unlawful in Maryland and in most places. Here in Maryland, we do have now some jurisdictions require security cameras for multifamily buildings. They are specifically required for what we call high occupancy. That means 100 units or more are required to have cameras now. No sound, though. Sound is the important part. If you've got surveillance cameras, then they shouldn't be audio recording. In most instances, that's always my recommendation. But it's also okay to put them in single family homes. Again, don't do it in the bathroom. Don't do it in the bedroom. Don't put them in places where people have a reasonable expectation of privacy. But you can have a Ring camera on your front door or on the side of your house or your rental property, and that's fine. I think it is helpful to have something in your lease about the fact that there is security cameras and surveillance going on, but not necessarily fatal if you don't.
And yes, you can have cameras all throughout the property, but there is that additional layer of making those cameras proactive for you. And so that's where, something like Cloud Structures remote guarding can come into play. It's really the idea of bringing technology and human intelligence together, where technology, those AI analytics, are telling our human guards, hey, there's something happening over here. And then those guards put their eyes on it and truly assess if it's normal activity, suspicious activity, if it's threatening activity, if they need to bring in the authorities or contact someone on your team, on your call tree. And so that's where we really create that proactive approach of being able to deter that unwanted activity from progressing. And so that's just that extra layer of being on the lookout for that suspicious activity of employees, tenants, so on and so forth. It's something that's really easy to deploy. Obviously, ultimately, it comes down to the budget of the property. But as I mentioned previously, the ROI on implementing a proactive security measure such as that could be entirely significant for your property management company. So I asked our security expert, Ed Burnett, his thoughts on employee screening and observable behavior, what you should watch for in your employees. So let's take a quick look here.
Every employee or vendor you hire is handed the keys to the kingdom, your kingdom, access to spaces and data that can make your business vulnerable. One mistake, one oversight, and the consequences can be devastating, legal, financial, and reputational. I'm Ed Burnett. During my 30 years as VP of Security for a Fortune 100 company, I was involved with the screening of thousands of employees and vendors. My job was to protect people, property, and operations. What I learned applies everywhere. Screening isn't optional. It's essential risk management. Screening must be standardized, thorough, and documented. Verify licenses, check criminal history, call references, and rescreen annually because people change. Financial pressure, personal problems, life happens. Pay attention to observable behaviors, lingering where they shouldn't be, unusual access times, inappropriate encounters. These are all red flags. Review surveillance, follow up. Consider remote monitoring. Screening isn't just compliance. It's how you protect your people, your property, and your business.
Great insight there from Ed Burnett, our security director. So I think we're coming up on the end of time. For sake of time, I think it's important to end here. Let's get practical. So if I'm a regional VP or an asset manager watching this, what should I do Monday morning? Melinda, what's the first legal audit you would recommend?
I would just go through and do a check of all of your employee files, your vendor files. Make sure that they have what you expect to see in there. Whether it's the background screening reports, your employment contract, the vendor contract, the information on the insurance policies, all of that stuff, you want it to be where it's supposed to be. You don't want to be defensive responding to an incident, and then you find out I don't have any of this stuff. I thought it was in this file and it's not in this file. It's kind of a pain in the butt to do just like a standard file audit, but I think that's something that if you're operating a business of any kind, you need to periodically do that. You should make sure that all of that documentation is in one place and it's retrievable, so somebody doesn't have to go hunting through somebody else's desk in the office to find this stuff. It should be in one place where everyone knows where it is. You need to have clear policies for how you are going to escalate things when they occur. Make sure your employees know who they need to report to, what they need to do to report the incident, whether it's a standard incident report form that everybody has access to or not. Make sure that there is a clear workflow in place for everyone so that everyone does it the same or as close to the same as you can manage it, because you don't want to have 10 different processes for one property. You want one process for 10 properties if you can manage it. You want to make sure that your surveillance usage is legal and also complies with your HR policies. So contacting a lawyer doesn't have to be me, but contacting a lawyer is usually very helpful whenever you're looking to put into place some sort of big surveillance policy or a change. I would reach out to whoever your local counsel is, ask them for their thoughts on it if they see any red flags. Make sure you send them the contract. They will ask you for the contract if you don't send it to them. And make sure that you're coordinating with risk management, operations, your attorney, your insurance company. Make sure that everyone is on the same page. That way, when something catastrophic happens, you are better equipped to deal with it. And frankly, I'd rather you be paying Cloudastructure or Megan on the front end than paying me on the back end to come in and clean all of this up, because it'll be painful for you and for me. For me too. So if you can sort of avoid these issues or be prepared for how to deal with them prior to them happening, that really goes a long way.
Megan, one final question for you. What documentation should be centralized immediately?
Oh boy, safety and security procedures should be centralized. First of all, there should be a copy at every location on sites as well as headquarters. And then keeping a site safe goes beyond those premises alone. So we talked about walking premises, checking lighting, things like that. Document everything. Document that the cameras are working. Document that the doors are locking and the doors are closing properly, that emergency lights are coming on. Check that. Check the dates on your fire extinguishers. Check everything, document everything. And no contracts should be signed without senior leadership approval to ensure that liability is flowing in the right direction. So there should be centralized procedures also on hiring employees and vendors, as well as what contract wording is acceptable. Regardless, trust me, there is often pushback on that contract signing because you may have pushback. So a management company may say, but the owners are pushing back on the indemnification requirements. Guess what? This is mandatory. No contract wording can be amended without senior leadership sign off. So centralize it, and then you will avoid a lot of problems after the fact.
All right. A lot of information that we just covered, and I think it's very, very valuable information. So I really hope you guys were able to take away some key points from this webinar. And again, thank you so much for joining. And thank you again to Melinda and Megan for all of your just great knowledge and insight. We really appreciate it and really appreciate you guys joining us again.
Oh, our pleasure. Thank you.
Thanks for having me. Happy to be here. And if I didn't answer anybody's questions to their satisfaction, feel free to shoot me an email. I will do my best.
We have our next webinar coming up Thursday, April 9th, and it's going to be regarding pool safety, another really important topic, especially as we're coming up on the summer months at your property management company. So go ahead and if you'd like to pre-register for that, you have the opportunity to do so. And as promised, each of our emails are up on this screen. Take a moment to write them down. None of us mind if you guys reach out with questions. We'll take our time to respond as needed. So again, thank you so much for your time. Thanks for logging in. And thank you again to our lovely panelists, Melinda and Megan.